Good afternoon, and thank you for joining us. I'm Bridget Anderson, the President and CEO of the Greater Vancouver Board of Trade, and welcome to our Business Resiliency series, Navigating COVID-19. Today, we are going to be focusing on contract performance. Many companies are or will be dealing with difficult questions around the performance of contracts during and following the COVID-19 pandemic. In this time of unprecedented uncertainty, we want to ensure that our members and the broader business community can find answers to their most pressing questions. Through a series of free webinars, experts will provide guidance and answer questions to help companies navigate their next step. We encourage you to take part in this discussion. You can engage with us on Twitter, Facebook, and Instagram by using the hashtag GVBOT. We are also using Slido for today's discussion to allow you to submit questions. You just need to go to slido.com and you can enter your questions. Do not forget the code GVBOT contracts. Now, before we start, and especially in these challenging times, we want to thank our long-standing partners called our pillar partners. They include TELUS, CN, YVR, BCIT, and Air Canada. We are very grateful for the support of these 5 organizations whose annual partnerships and commitments allow us to do our important work. Thank you as well to our preferred media partner, Business in Vancouver. Today, we are joined by Brent Meckling. Brent is a partner and co-chair of the Business Litigation Group at Clark Wilson LLP. He has over 25 years of experience as a litigator with a focus on commercial contracts, shareholder disputes, real estate, and alternative dispute resolution. Brent, I'm going to hand it over to you, but first I'll just maybe do a little bit a caveat here. You have incredible expertise here on the legal front, but it should be a reminder to everybody this is not specific legal advice that you're giving today.
Thank you, Bridget. It's a real pleasure to be here today. I'm looking forward to our webinar, and I hope that we can impart some knowledge and some ideas and information to your membership today and help them navigate what obviously is an unprecedented time in the business world and society in general. So with that, I'd like to start with my slides. And what I've done for today, Bridget, is I prepared a checklist for companies to prepare for contract performance issues. And I think whether or not a company is anticipating it won't be able to perhaps perform some obligations, or whether a party with whom it's been dealing with over the years, or perhaps for only a few months, that party might not be able to perform its obligations. So what I've done is create a checklist of items that I think businesses ought to be looking at and considering as we work our way into the month of April here, and things really become potentially more difficult on the business side. Now, before I get to the checklist, what I did at the opening slide is I've made a quote. This is my quote, and what I've said is, once in a century pandemic does not alter the fundamental starting point that written agreements will govern the parties' rights and obligations. And what I mean by that is I just want to emphasize that the sanctity of contract law doesn't disappear just because we're in unprecedented circumstances. As your membership will know, contracts represent a bargain. They represent an allocation of risk. And absent specific contractual terms and some other legal doctrines which have somewhat limited applicability, the parties' rights and obligations are going to be governed by the written agreement between the parties. Now, on that point, I think we can start with the checklist now that I've prepared against that backdrop. And these are items that, as I said at the opening, I think all businesses ought to be considering to arm themselves, to be knowledgeable about their rights and obligations as they deal with these issues that I'm sure are going to crop up. So the first item I've got on my checklist is assemble up-to-date versions of all existing contracts. That may seem like an obvious point. However, it is not uncommon for businesses to have operated for years without ever looking at the written agreement they may have with the other party. There may be extensions or amendments to that agreement that are sitting in a drawer somewhere. Perhaps they haven't been executed or signed. Nevertheless, they may govern. So I think it's very important for businesses to make sure they are dealing with up-to-date and current agreements with the other parties with whom they are dealing, so that there's no misunderstanding as to what written agreements are going to govern the relationship between the parties. The second item I've got on my checklist is to identify and prioritize the most vital agreements and assess the potential for default by either party. And really, that's just an organizational issue for all businesses to take care of. And I'm sure by now most businesses will have already start to have felt pressure points in their business relationships, in their supply chain relationships, and there's probably already certain pressure points they are feeling in terms of their ability to perform or other parties' ability to perform. And so I think it's important to at least prioritize and deal with the most important agreements first, at least initially. There may be time down the road to deal with lesser items, but at least initially it's important, in my view, for all businesses to identify the most important business relationships and agreements that they have as we move into the month of April. Now, moving on to the next slide. Here, I've got an item respecting the government COVID regulations, guidelines, or financial support, which may impact performance or mitigate losses. And as we all know, it seems to be on a daily basis that regulations, guidelines, programs are being implemented and rolled out by either the federal government or the provincial government. And certainly there are going to be both operational restrictions and guidelines in terms of what a business can do, in terms of employees, in terms of their operations. Are they an essential service? Those will certainly impact on their ability to perform their obligations, or it may impact on the ability of the other party to perform its obligations, as well with government loan subsidies, deferrals of all sorts, and those kinds of things that, as I say, are being rolled out on almost a daily basis. There are going to be routes available to businesses to alleviate some of the pressure they're feeling on the revenue side or on the expense side. And certainly those are things that are going to have to be considered when we're looking at an ability to fulfill contractual obligations. So those should be front and center as well in any business's consideration. The next item I've got on my checklist deals with what many of your membership will have already heard in the news, and those are force majeure clauses. And these are clauses that are contained in many, but not all, commercial agreements. They are typically the kind of clause that's known as boilerplate, and that business people typically might look over and not really pay much attention to. Certainly nowadays, they are front and center in everyone's mind. And really a provision like this deals with the suspension of performance for events beyond the control of the parties. And as I say, they're commonly called force majeure clauses. And on the next slide, what I've done is I've taken or found among the many provisions that appear in agreements that are called force majeure clauses, I found one I think that might be useful for us to look at, because it identifies a number of key parts of these kinds of clauses that need to be front and center in businesses when they're seeking to invoke this kind of a clause. And as we work our way through this definition, I won't read the entire definition, but what they deal with when it, and in the second line we see it talks about the extent that such performance is prevented. And these clauses really deal with situations where there's an impossibility of performance, typically not just inconvenience, typically not just increased costs. It really deals with an inability, an impossibility of performance. And so those are the kinds of situations that these clauses will typically deal with. You'll see further on in this definition of force majeure, at least the one that I've used here, there's an obligation for the party who is non-performing to promptly provide notice to the other side. And that's always a key consideration here for the non-performing party who's seeking to invoke force majeure. You want to make sure that you comply strictly with whatever notice provisions are contained in that clause or elsewhere in the agreement. These kinds of clauses are strictly construed by the courts. So if you're going to invoke this kind of clause, you want to make sure that you're strictly complying with any notice provisions. The other feature that's typically a part of these force majeure clauses is that they are temporary in nature. They do not permit a party to essentially walk away from their obligations. What they do typically is suspend performance of obligations, and that suspension of performance will typically only be in place so long as the intervening event remains in place, or remains an intervening event which is making it impossible for the contract to be performed. So they're temporary in nature. They're about the suspension of rights, and that means also that the non-performing party has got to take steps within their power to mitigate their inability and to mitigate their inability to perform under the agreement. So that means they can't sit on their hands. They've got to look for alternate ways to perform the contract and not simply wait for, in this case, the COVID pandemic to run its entire course. They've got to keep looking for ways to alleviate the event and its impacts on their performance. Finally, and this is in this particular case in terms of the COVID pandemic, the definition of a triggering event will obviously be key in terms of whether or not these kinds of clauses can be invoked. In this particular clause that I've found in some other agreements, you will see that an epidemic is actually defined as a force majeure event. Not all of these clauses will include epidemics or pandemics as a triggering event. So, as I say, this particular one has an epidemic as a triggering event. However, all clauses do not contain that, at least in my experience. Nevertheless, there may be room still within the definition of such a clause to find room for it to be enforced and for it to be invoked. For example, this particular clause talks about a regulation, law, or order of any government. So there could be an argument that various guidelines and regulations put in place by government are impeding a performance such that this clause could be invoked. So that's a summary of force majeure and the impacts it can have in this kind of situation. So on the next slide, I deal with some other provisions that are commonly found in agreements that any business will want to have a look at. The first one that I've noted is timing of performance and consequences of delay. These kinds of provisions are often found in contracts, and this would be something that's separate and apart from a force majeure clause. And often there are requirements for the non-defaulting party to send notice to the defaulting party to demand performance within a certain time frame. So that's the kind of clause I'm talking about there that ought to be looked at. The second item, exclusion of liability or limitation of damages. Again, these are clauses that are commonly found in most commercial agreements. They can limit the exposure of a defaulting party to have to pay certain damages that may flow from their breach of contract. And they also may, in terms of liability, limit the kinds of breaches or the kinds of activities that will constitute a breach under the agreement. So obviously those are going to be clauses that will need to be carefully looked at. There's usually separate clauses in an agreement dealing with the termination of the agreement, separate and apart from timing of performance or even a force majeure clause. So those will have to be carefully looked at to see what grounds there are for terminating a contract, or just even how long the agreement has to run. The fourth item I've got noted there is dispute resolution procedures. And those will refer to the methods that the contract spells out for resolving disputes. And certainly issues of performance, issues of ability to deliver under a contract can certainly constitute a dispute under the agreement. And most agreements, or at least many commercial agreements, will specifically provide a resolution procedure. It may constitute good faith negotiations, followed by mediation, followed by arbitration, for example. There may be those kinds of clauses. So those may dictate to the parties the route they need to take to resolve any differences they have or differences they see on the horizon in terms of performance. So the form and nature of those dispute resolution procedures are going to have to be closely looked at so parties know exactly what the road ahead might look like for them should a dispute arise and should they need to resolve that dispute outside of a simple negotiation. The final item I've noted in terms of specific contractual terms that you'll find in many commercial agreements is one dealing with choice of jurisdiction and applicable law. Jurisdiction and applicable law are two different concepts. Jurisdiction is really the form in which any dispute needs to be resolved. Is it a foreign country? Is it Canada? Is it British Columbia? Is it an arbitration forum? Applicable law means that even if a contract is performed in British Columbia, the agreement might provide for the law of a different jurisdiction to apply. Parties may not want that law to apply. It may be draconian. Certainly many contracts will be governed by Commonwealth, the common law of the Commonwealth countries, and also by United States law. That would be a typical arrangement. However, the scope of the potential for applicable law to relate to any country in the world, depending on the agreement at issue, is certainly broad. So before going down the road of litigating any of these disputes, the parties are going to have to look carefully at what law applies, and if it is foreign law, a determination is going to have to be made about what that foreign law says about all of these issues of performance and obligations under contracts. So those are the items that I think are important to look at in a contractual setting. On the next slide, I deal with issues that aren't related so much to the agreement itself, but rather matters outside the agreement. The first is insurance, and certainly there's going to be business interruption insurance in place for a lot of businesses. Insurance law is a specialty unto itself in many respects. However, it's important to look at those business interruption loss provisions in any insurance policy because they may provide a route for businesses to recover at least some of their losses that they might sustain because of this pandemic. The second item I've noted on this slide deals with the utility of litigation versus the preservation of commercial relationships. And by that, Bridget, I mean essentially, do you want to disrupt what might be a very valuable and productive business relationship by commencing litigation against that party if there is a default? The COVID pandemic will end at some point in the future. We don't know exactly when that is going to be. And there may be relationships that are worth preserving. There are probably many of them actually that are worth preserving. And so, businesses are going to have to carefully consider whether they want to use any hammer they may have in terms of their strict legal rights versus the eventuality that these people and these businesses and companies are going to have to probably pick up these same business relationships down the road, and we have to seriously consider the damage that can be done to those business relationships through litigation. The final point I make on this slide is simply that businesses need to be careful about entering negotiations and taking positions on all of these contractual performance issues before they seek legal advice. There can be occasions where steps taken can constitute a breach of an agreement inadvertently, or perhaps steps taken in terms of granting obligation or relief from obligations may have unintended consequences in terms of extinguishing rights. For example, are you just deferring payments or obligations under a contract, or are you actually waiving them and completely abating them? So it's important for all businesses to obtain legal advice in my view, before going down the road of negotiating resolutions to what are certainly difficult problems. But steps can be taken inadvertently, which can impact your position in ways that perhaps maybe were unintended. So that's my final point in terms of the checklist, Bridget. So with that, I would turn it back to you, Bridget, and I'm happy to deal with questions from yourself or your membership.
Thanks very much, Brent, and that's a great checklist. So, you know, you had some really good points in there, and particularly around not waiting for this pandemic to subside before dealing with some issues that might come up, but also then trying to balance the significance or the importance of relationships. So when companies recognize that they might not be able to meet the obligations in a contract, what should they do to try to minimize the consequences?
Well, I think it's really a matter of negotiation in the first instance. And as I say, I think it's negotiation, though, that is informed by their rights. So I think any businesses, when they start those negotiations, it's a good idea, and this is really reflected in my checklist, Bridget. In my view, it's more than a good idea. It's absolutely essential for them to understand what their rights are, no matter which side of that equation they're on. But in my view, certainly a good faith negotiations initially in any dispute in this environment that we find ourselves in is certainly the most pragmatic and I think the most useful step to take at the outset.
Now, for many of our members, one of their priority contracts really has to do with their lease payment or their rent payment, and that's where a lot of members are really coming up to some challenges in being able to pay their rent. And so is this your advice as well, is when they're dealing with an inability to pay because they're not seeing revenues come in, is that the first step they should be taking with their landlord, is that negotiation or that communication?
Absolutely, and I think we're already seeing in the media reports, Bridget, of accommodations being made by landlords. It's always going to vary from situation to situation, and you know, the law of landlord and tenant, I think most of your members will know that it is, at least in my view, skewed fairly heavily to the landlord. However, of course, landlords want tenants, want their buildings filled with tenants, and certainly want, as I say, in the future when this pandemic passes, to have good relations with tenants they already have. So there's certainly a good motivation, I think, on the landlord side to deal constructively with any approach made by a tenant, you know, in these times.
And then there are companies out there that are looking at their contracts that they have signed since maybe that second or third week of March. So since the social distancing or physical distancing guidelines came in place, since essential services designations came into place, when looking at that period really of the last, 2 to 4 weeks, would there be specific advice that you would be giving because we're in the middle of the pandemic now?
Well, it's, you know, in terms of agreements, if I understand your question right, Bridget, I mean, in terms of agreements that have been entered into in the last, say, 4 weeks, I mean, that raises some interesting questions, because these principles that and doctrines that I've mentioned, in particular force majeure clauses, and there's another doctrine that we didn't really touch on, but it deals with frustration of contracts, and that's a common law doctrine that can be invoked at times in certain limited circumstances to terminate contracts. The application of any of those doctrines, it's usually based on what was known to the parties at the time they entered the agreement. So if we're talking about agreements that have been entered into in the last four weeks, for example, you are probably going to get a different set of considerations and perhaps different outcomes when we're talking about what was in the contemplation of the parties when they entered the agreement, and therefore that will have implications for the rights in those agreements and how those rights are interpreted and construed by the courts if it was to get before a judge down the road.
Okay, great. So let's go to Slido and see some of the questions that are coming in from some people who are watching and listening into the webinar. And really, one of the first questions I think that we're seeing here is about employers' obligations. Most people now are working from home under the guidelines and recommendations from health officials. So what are the employers' obligations to those working from home?
Well, again, the law of employment law and labor law, again, is a very specialized area, Bridget. But what I would say is this, that you know, employers certainly have an obligation to provide a safe work environment for their employees. And if that can't be accomplished at their regular place of employment, I would say, generally speaking, there is going to be an obligation to accommodate employees insofar as the safety of their workplace is determined.
Great, thanks very much, Brent. We'll go to another question now on Slido and take a look at what people are asking here. So what are some contractual risk employers should be aware of and as we're navigating? So I think we've gone through force majeure, we've gone through some of those if you're in a situation where you can't meet some of the obligations of your contract, but are there some risks, the other risks that you haven't covered yet that they should be aware of? Well, again, as I say, you know, the employee-employer relationship can be a complex one. Often there is no written agreement, and I would hazard to guess, Bridget, that the majority of employment relationships in this province and probably in Canada are not governed by a written contract of employment. So in terms of contractual risks employers are dealing with, it's really just you know, what sorts of work arrangements are they obligated to provide? Are they, you know, what sorts of work are they obligated to provide to the employee in terms of the nature of their duties? And what I mean by that is the workflow, is the nature of the work, is the character of the employment staying the same for this employee as it was prior to the pandemic? And that leads to all sorts of issues about, is this employee being constructively dismissed if the nature of their work changes, and all sorts of issues related to that. But again, Bridget, I would say that employee and employment law and the risks that employers face is quite a specialized area, and I wouldn't want to go beyond that in terms of commenting on that question. Great, then we'll go to this the second one here about legal remedies for those who are in the process of buying or selling properties and only receive 10% down. And I guess I'm just taking a look maybe to read between the lines there on that question. So only receive 10% down and then they are sort of stuck, I think, at that point. I think that's the purpose of that question. Right. Well, you know, going back to my opening comment at the beginning of our webinar, the presence of the pandemic does not relieve in some sort of you know, duty of fairness or reasonableness upon the contracting parties. It doesn't relieve a contracting party from their obligations. So the ability of, in this case, if you're a seller, to enforce an agreement against a buyer of a property or a business doesn't really change because of the COVID pandemic. So if it's a breach of contract for failing to close a sale, those remedies, you know, a remedy of damages is still available. Again, subject to specific language that might be present in any given agreement. The arsenal of rights and remedies available to contracting parties is still there. Now, the question of, is it worthwhile to pursue that party? Do they have an ability to pay any award of damages that you might obtain? Those are, of course, other questions that need to be addressed. But what I can say, generally speaking, and subject to the specific terms of any given agreement, a buyer is entitled to enforce that agreement against the seller. And you know, this question here at the top goes to the part that you were speaking about, maintaining relationships and how important that is, because this pandemic will be over at some point. So when you look at vendor-supplier contracts, what level of flexibility is appropriate when you're seeing this kind of disruption? Yeah. Well, that's going to vary from business to business, but I would say that
a fair bit of flexibility is required in these times. And I say that because even if a party feels like they are very strong in their legal position, and even if they may have what might otherwise be a completely solid claim that could be pursued in the courts all the way to judgment, I think that businesses ought to expect that if they sue and pursue litigation, that down the road, our courts will do, I won't say whatever they can, but there may be a heightened awareness and a heightened pressure perhaps upon our courts to find ways to alleviate some of the impacts on the defaulting parties if it got to litigation down the road. So that's all a way of saying that although in my view, it is business as usual from a contractual point of view, I think there are going to be realities to the extent that some of these matters make it before a judge down the road, that those judges may be looking at ways to alleviate what might be otherwise pretty draconian results against defaulting parties. And that ought to be kept in mind in terms of how flexible the non-defaulting party wants to be.
And we have time for one more question, and perhaps this is linked a little to what you were just saying right now. So if there's not a force majeure clause in a contract, what then, whether we're talking about a commercial lease agreement or a supplier vendor, I mean, does that force majeure, if it doesn't exist, how will the courts view that then?
Well, I alluded to a little bit earlier, Bridget, a doctrine known as frustration of contract, and that's a common law doctrine that can, in certain circumstances, alleviate the obligations of a party under agreement. However, what it does essentially is terminates the agreement for both sides and doesn't necessarily affect obligations that already exist at the date of termination. So while there may be routes around a lease, for example, with a landlord in the absence of a force majeure clause, those routes to safety, if I can call it that, for tenants are quite difficult to obtain under our system of law, under this doctrine of frustration that I've mentioned. So, absent a force majeure clause and absent, a willingness of a landlord to negotiate some workaround solution, I would say, unfortunately, that a tenant's options are somewhat limited in today's environment.
Well, certainly, I think as we get through this pandemic, legal advice will be more important than ever. So, Brent, thank you very much for your time today. I do really appreciate it.
It's been my pleasure, Bridget, and hopefully we've imparted some useful information to your membership, and I wish them all the best.
Thanks very much, and stay well, Brent. Now, to watch this webinar again, you can visit theboardoftrade.com, and it will be uploaded within the next several hours. And we are going to continue this important conversation, and we'd like to stay connected with you. So we're going to be hosting a series of free webinars on navigating COVID-19. And up later this week, we'll have some tax tips for small and medium enterprises with MNP. And then later this week, we're speaking to the Honorable Mary Ng, the Minister of Small Business, Export Promotion, and International Trade. We have also created a business resource page designed to help you with information and toolkits and resources to help you through and to navigate COVID-19. This resource page will be updated as new information becomes available. Thank you to everyone for being part of today's webinar. We look forward to seeing you again soon. And to echo the wise words of Dr. Bonnie Henry, our Provincial Medical Health Officer, be kind, be calm, and be safe.